Good morning, all. Today I'm going to have the fourth lecture, fourth A indeed. The lecture, this is on theory of property rights. So far, we have actually had enough of the introductory lectures on especially law and economics and its role in development. Then we have seen that what are the tools and concepts which is no which in fact comes in the analysis, and we have seen a little bit on a critical perspective on that, and now we are moving directly towards the core concept of the law and economics, especially on different laws and principles where how we can apply economic analysis. Now, as a first lecture of this kind, this is on the theory of property right, and property right is one of the most important concept in economics and in the legal system. However, from an economic analysis point of view, property right is the formalization of property right has done very not so rigorously like in the case of contract or tort. However, there are a couple of attempts to do formalize the theoretical perspective of property right. The most of the studies of the Chicago School and the new classical attempted to do that, but however there are a lot of different view on formalization of property right due to its inherent its inherent implication in the field of law, and indeed the very idea of property itself is having a divergent view, and because of that there are so many different strands of understanding regarding this. So that is why the formalization of the property right is often comes with a very different take in the real world. So again, there are different schools have different meaningful discussion and deliberation in this concern. However, there are a few structural or basic acceptance of the concept of property. So, in this smaller, attempt, what we are trying to understand is to develop this property right from certain perspective, and then we'll discuss about it. So, what are property rights? In the book Economic Analysis of Property Right, Joran Barzel had formalized or he was attempting to define property right. This is a nice book which is on one of the first book on economic analysis of property brought out by Cambridge University 1988 or 89. Yeah, 89. So Barzel's reviewed property rights carry two distinct meaning in the very introductory part of the book. That is one developed by Arman Alkian 1965 and 87, that was mostly formulated or conceptualized, and the other one is basically other part is developed by Chung. So in 1969, his book on contract farming and all. So both these people were trying to crystallize property from an economic angle. This is one. This is essentially the ability to enjoy a piece of property angle, or what we can say is actually the functional aspect of property. So other much more prevalent and much older perspective is essentially what state assigned to a person. This is what is called the legal assignment, or what to say that the first one is called the economic property right, and the second one is called the legal property right. So why it is economic property right? It is talking about the ends than the means. That is the ability, or whether the person is having the right, or sorry, whether the person is having the whether the person is basically enjoying a piece of property or a piece of commodity. That is, it is the end. So in that sense, it is actually talks about the ends. At the same time, what is the legal structure is talks about is it is the means, who assigns what and how it has been assigned, etc. So this is kind of a distinct paradigm. So in my view, I've always been critical about this thing, and my own work is basically on property right. What I feel is that economics, as Lionel C. Robinson talked about, it is actually ends and means, not single-handedly ends or single-handedly means. So the end is also dependent on the means relation. Therefore, leaving means relation or discounting mean the process is not that good to have a comprehensive understanding of property. So this is a kind of a basic premise which we will be working on. So we will discuss our further clarificatory points in this regard. And economic rights are the end in that sense. That is what people ultimately seek. Other sense and concern about the efficiency. Now, when you say about, as I pointed earlier in the earlier lectures, that when I am speaking about efficiency, I am talking about a situation which is actually achieved some sort of a givenness. Therefore, in the Perettian sense at least, so in that context, when I say efficiency, I can compare only this with some other thing, then it is having a problem of incomparability. Just like what Lionel Robinson himself said, that is the interpersonal comparison of utility is impossible or difficult to conceptualize. So the legal rights are the means in that context. Again, legal rights are means to achieve the end. That is, in our last lecture we saw that it is compatible with equity and fairness in that context. Again, it is not only equity and fairness. From the economics point of view itself, it is basically flows from the fact that economics is studying ends and means, not only the means or the end. So it is actually a combination of both. Therefore, the importance of the legal understanding is very crucial as far as the lecture is concerned, as well as the very concept of property is concerned. So here let's concern primarily with the legal rights first, because the economic right to property we will discuss later. Why? Because it is an end. So first we have to see that what is the process where you achieve or kind of formulate property right, and the classification may lead to understand the evolution and the outcome of that evolution. So let us come to the point of property right defined. That is normal. There are many, as I said, there are different strand of views on property, and claims to use. For the first one is claim to use or control a resource that are recognized as legitimate by some entity or entities larger than the individual and protected through some type of social or legal sanction. Now, property right is a claim or to use or control a resource that are recognized as legitimate. This is very important. This is most important part. It is recognized as legitimate by some entities larger than an individual. So if I would say that I have right, this right comes from the first and foremost thing is with somebody's permission or acceptance. That permission or acceptance is not from a very individual of the other side, but other than or bigger than the individual. It is something which is in the mind that the third party has to assign or recognize or claim, then only it becomes a right. So in India or in the United States, it should be the constitution, for example, not even the state. It is constitution. Whether the constitution accepts your claim, or then you can say that that is, or your rights has to be guarded by the constitution. So then you can say that it is more than an individual. Constitution is superior than an individual per se. So this is a kind of definition. So property right is something, or any right is something which has to be recognized by other third party. So this is very clear. For in our perspective, a right is always a claim which is recognized by a third party or approved by or guarded by the third party. All right, then only it becomes, because as an individual it's perfectly logical that as an individual I cannot say that I have a right to myself. So why? Because if nobody accepts that claim, it remains as a claim, because there is no enforcement, there is no sort of looking after. So you yourself say that I have right, and you, so that is not necessarily something which can be exercised. So key component is that property right entails right with respect to benefit streams of values and duties of others to respect those rights. So this is the most important portion. So I am not only in that sense, when I say something which is comes with right, I am not only saying that I have claim, but also others have duty. So when I am saying in the economic analysis, when we speak about the independence of individuals' decision or individuals' thing, this is not actually any longer applicable here. Why? Because here everything is interdependent. So I am transacting a commodity in relation with the other person duty that the other person agrees what is my transaction. Oh, see, this is what is we try to basically articulate in any transaction. This is why I asked in the previous lecture I hinted on the fact that why people are not snatching, or why they should not snatch. There is a moral sentiments. That moral sentiments gives the commodity transaction a rightful commodity transaction. So that itself comes with a kind of underlying premise which is called right, which essentially comes with a duty. So, or I would say more clearly, like it comes with a claim and essentially backed by a duty on the other side. So granting rights and enforcing duty requires competent legal or social authority, therefore, who can be called upon to enforce rights and duties. In some case, the authority may need to defend individuals' right over the apparent interest of the collective. So this is the fundamental idea of this thing. So who is actually formalized all this kind in the very beginning? So there are many works, including William Blackstone or Austin's. All these people were in fact try to articulate different strand of the characteristics of right in their writings. But essentially in 1913, the paper which was brought out by Hofield in the journal Yale Journal, that has been treated as one of the essential writing on the property right conceptualization, because the two part paper, that is one appeared in 1913, the other appeared in 17, and combined together, they later it was published as a book, because the person was demised at a very short age, at I think less than 30 or 35 years. So what happened is that this conceptualization is being treated as one of the best conceptualization so far on the idea of right, and with all the discussion and dissent which we may be actually also encounter in the coming lecture. What his proposition and the formalization of the right? He defines right to have a right, or conceptualize right to be right if and only if it has this relationships. That is, he is making two relationships. That is, a right comes with the two kinds of jural relationship. It is jural opposite relationships and jural correlative relationships. So this is actually a kind of reciprocal existence of different claims, okay, and duties, liability, whatever. So duties and liabilities really. So what is the first jural opposite? What he is trying to make is actually in order to define something right, something as right, you should first of all have a claim. This is well and good. It is comes with any commonsensical logic. That is, you should have a claim over something. Then only you can go for whether it is having, whether you are having right over that particular thing. So it comes with the claim. So when I am saying that this computer belongs to me, then it belongs to me comes with an idea that nobody else is claiming that that belongs to them. So this is what is called the relationship with opposite relationship between claim and no claim. Originally in the paper 1930 paper, Hofield conceptualized it as no right. So right and no right. So that is a bit confusing, because the very title itself, property right or right, formalizations, and then we just changed the name, that is claim, and because in the paper he refers to this claim and no claim. So what we are trying to say is actually a claim comes with a no claim. That means when I am saying that this computer belongs to me, nobody else should say that this belongs to them. That means no claim to other person. So this is one thing. So it is commonsensical. And then he also tried to conceptualize that, a privilege. So if I am saying that today I am going to speak, or what you say, that somebody has been invited to speak. So somebody has to speak means they are privileged to speak. So it comes with the duty. It is opposite is duty. How do we define it? So very simple. A privilege is, for example, if my class is having say 25 students, I am asking one person to come and give a Thanksgiving note, then it is actually the person is privileged to do that. Or I am teaching the students, then I am privileged to teach. If the authorities say that I should not teach this particular course, then my privilege been taken. Then I am dutiful to accept that my privilege is being actually taken. So that means privilege comes with the duty. Why the 20 out of 25 people, one person been called, and why the other people are not disputing? Because they are dutiful to that particular assignment, that is the privilege which was given to that particular X individual, and all the non-X individual are dutiful to that particular invitation. So that is why we call it as a privilege, but it is not a claim. So that particular, now remember, this is actually completely different from the claim and no claim. A claim, you have actually you are self-claim for it. All right, you have a legitimate whatever, you feel that belongs to you, but in the privilege you don't feel that you should be called, but you are called. All right, both are different. So this is only called a privilege. That privilege is actually a lesser form of what is called claim, and what is actually the opposite of that, the other people are dutiful to that call. All right, so this is the distinction between. So you should have these two things together. one is claim and then the other one is privilege. Then you also have another the third conceptualization that is called the jural opposite, which is power and disability. All right. Then if I am saying that this computer, again the computer example, computer belongs to me, then that is a claim. Then there should not be other person who claims it. Then privilege means I am privileged to have this because if I have money or whatever. So if that has to be respected, dutifully respected by the other, and then I have power, right? Then I can use this computer as I can use the computer, which is my power of utilizing this particular kind. That means the other person doesn't have that power. So power comes with the disability. If I have power, then the other person is not having power. Similar, this is also logical. Why? If the authority, for example, if I am the teacher, then the other students are not teachers. And then you are the student, then I am not the student. All right. So this is actually reciprocate. This is opposite. Actually, these two things are basically opposite. Okay. If I have power, that means you don't have power. All right. If I have power and then you have disability. If I have power to exercise something, then you have disability to exercise that. Then only you can say that I have this right, then you. All right. Then the third one or the fourth one is called, and final one is called the immunity kind. So suppose if there is a problem, power, privilege and claim, then I am immune from somebody else's intrusion. Okay. So this is what is called the protective thing, which has to be ensured by the other person. All right. Which is we call the third party. So the immunity comes with somebody is guarding this. All right. So I have a claim, I have privilege, I have power. But if nobody is actually accepting, or nobody is there to look after or ensure that my power is exercised or privilege is being guarded or claim is fulfilled, then I still don't have right because immunity is not there. So on what ground? So this question comes, what ground this is all can be guarded? So this is the important aspect of immunity, and immunity comes with the liability. If I am immune from it, then you are liable. If any breach you make is going to be going to inflict a liability upon you. So this is again doing by liability is always been assigned by the third party again. So this is also the fourth concept which comes under the property. So this is what the in a nutshell Hoffieldian concept of rights, especially the jural opposites and its fulfillment, is an essential things to have something right. All right. So then he is trying to make a point also that it is not only this opposite matters, but there are certain things which also goes together. All right. So these are called the jural correlatives. All right. If I am saying that I have claim, then if I have a claim, then you have a duty. So this is goes together. It cannot be independent. All right. If I make my decision, then it is independent. It is not independent. The other person is actually your decision is dependent on the other person, because if the other person is not dutiful, then you cannot have that sort of a claim. Okay. So your claim has to, or your right has to come with a duty, a sense of, so it goes together. It won't actually go opposite. So right is claim is right means claim. In the original paper it is right. So claim is basically comes with a duty. All right. Say similarly the privilege is also come with a no claim. So that means if I am privileged to speak, that means no claim comes with from the other side. No, that means the other person has no claim. So it goes together. All right, at the point if somebody is actually objecting that I want to speak, then your privilege is being questioned. So if that is why called it as goes together. The privilege of yours is actually undisputed so long as it is undisputed. That's it. If it is disputed, your privilege has gone. Then comes with power. Power is also comes with liability. Okay, if I am saying that I have actually power to exercise something, then it is equal to say that if somebody else do the same, then you are liable to do it, because you say that if I have power, then somebody else has power, means you are liable. So if you have power, the other person is liable. So power and liability is actually goes together. This is also called the dual correlative. And then immunity and disability. If I am immune from something, means the other person is disabled from it. Okay, if I am suppose I am saying that my computer is firewall, that is immune, that means the virus cannot, virus is disabled. All right, so this is what is goes together in that sense. So right, privilege, power and immunity is having a correlatives of claim duty is claim privilege, power, immunity comes with a correlative of duty, no claim, liability and disability. So see, this is a flipping of the 8 concepts. So these 8 concepts, as far as Hoffieldian concept of right is, sorry, to put it differently, Hoffieldian concept of right is being articulated based on this 8 particular 8 concepts. That 8 concepts are called the essentials of determining right. Okay, so universal right. So this is why this is most important, because when I say that right is something, as I said, universal, right? So if you say that I have right to something, then I should have all this claim, privilege, power, immunity. These are minimum things. Okay, these are minimum things, but these minimum things are essential to have a sort of a comprehensive view on this particular thing. So any of this 8 thing is questioned, then the existence or the absoluteness of or the abstractness of this very concept with us. This is the point. So in the legal doctrine, this Hoffieldian right is very keenly debated, and it has been treated as very essential to understand the very concept of. Now if you look into the constitution of any country, these are the things which is maybe there in most of the, even the universal human rights declaration. This is what is actually try to inculcate through. All right, so I'll come to that point later. So in the property also, this is having a very important take. So now the question is that, now if I am defining right, which is based on Hoffieldian conceptualization, then that is called a universal right. Now that is formed as a right. Now the question is that whether that right is equal to ownership. Okay, so is right equal to, then it is also asked a question that whether this right is entitlement, or is it different, or is right different to that of ownership, is right different to that of entitlement. Normally if I ask that whether right and ownership is one and the same, normally everybody say disagree with it, and it cannot be, because it's two different things. Right, ownership is different, right is different, because of our sensibility that ownership is somebody owns, right is somebody not owns. So this is a kind of, it opens a very new way of looking at the problem. So ownership is by itself means that you possess. It comes with actually an idea of possession. Okay, you own it, you possess it. Okay, at the same time the very ideal way of right is comes with a claim. All right. Okay, you don't own, you claim it. Okay, so one is claim and that has been accepted. So accepted claims and duty, this claim, privilege, immunity and power, that is forms the right which is agreed upon, whereas ownership is actually not only agreed upon, you have a furtherance of it. So we will discuss that difference. Then again, a right equals to entitlement. These days nobody talks about, economists especially from the work of Amartya Sen. He talks about entitlement, and his book is also the entitlement approach and other things which he keep talking about was it is a given thing, of course, as in connection with the right, it is near to it, but it is not right. Okay, so these days nobody talks about rights. I have a right, or A is having right, B is having it. These economists are interested to talk about entitlement. Entitlement is something you have, okay, already given. So something already given and something you are already having, whereas right is not necessarily that, isn't it? So these are the tricky way of understanding the difference between what is the right and what is ownership and what is entitled. So what is ownership? Let us move towards these fundamental questions. So in the observation of owner, for example, in the observation of owner, a British jurisprudence expert, he defined he tried to articulate his concept of ownership as incidence. All right, in his paper, especially it comes under the lectures of jurisprudence book, which was brought out by Oxford University. This forms as one of the chapter in that book. So in the lectures on jurisprudence, this paper 1961 formed very, very important. This has opened a very new kind of understanding of all this thing. So in the observation of ownership comes with incidents. What he is defined is that certain incidents are there, and that incidents are his ownership. All right, or somebody claims that he is the owner of something, then this is actually comes with this set of. So ownership in that sense is a claim, but that claim comes with a lot of incidents. All right, so that is what we are going to talk about. So a final use or claim of ownership depends on 11 characteristics. So what he says, the use or claim, what he is trying to pick up is from the right, the conceptualization of right of Hofield. Hofield tried to say that if you have 4 things and 4 opposite or 4 correlatives comes together, then only you can have right. Okay, or to say that if you have something, then that something comes with the 8 characteristics. Okay, so that 8 characteristics should be made, and then you can define it as right. At the same time, what owner says is out of that 8, if you pick one, that is claim. Ownership is a claim. Suppose if it is a claim, then that claim has 11 characteristics. See, the subset of right is what is called an ownership. Ownership is a subset of a right. Okay, in that sense, that is, you have a claim, and that claim is now backed with 11 incidents. Okay, this is what he is trying to make. So if these characteristics follows, then we can say that the owners is absolute owner, and any violation violates the absolute ownership on the contrary. So let's discuss the incident of ownership in that. See, this is very tricky also. And what are these incidents? Let us first look into this incident. See, so if I am saying that I have a claim, then what are these claims? That 11 incident the claim has: right to possess, right to use, right to manage, right to income, right to capital, right to security, incidents of transmissibility, absence of term, prohibition of harmful use, liability to execution, solvent residuary character. Now in that you have a little bit, the first things are very interesting, because let us go one by one in the incident of ownership. Right to possess, that is physical occupation. So when I say that I have a claim, I have a physical occupation. What I mean is that I can physically occupy the thing, physically occupy or non-physically occupy. For example, intellectual property right. So it is not actually a physical occupation, it is an intellectual, that is non-physical. All right. So right to use, so you have a possession, so this knowledge belongs to you, so you have a claim that the knowledge belongs to you in under intellectual property right. In the physical capital then or property, you say that this is physically belongs to me, or the occupation, the physical occupation of the thing is what is mine or what is yours, distinction, or it creates a distinction of what is mine and what is yours. So right to use, again, now my claim is also to use the thing. All right. This is enjoying the resources. So this is enjoying the resources means this is what is actually in the economic theory we dealt with, the end result. Okay, whether I am having it, because for example a security person is physically occupying that land space, but he is not the owner. Nobody says that a security person is the owner. Security person but physically occupy the place, and he or she is actually being recruited there to guard the thing. This is what is for all of us, it is clear, but he never been the owner, or he never been treated as that particular thing is comes with the right, etc. So it is very clear. So very pretty clear roadmap to what we talk about. So right to possess doesn't mean that you are the owner. Again, right to enjoy the land. If you are going to some places and you are seeing sight, you are enjoying the place. It doesn't mean that you own the place. All right. We all go for, we enjoy the thing, doesn't mean that we own the thing. So distinctively you can't say that one incident if you meet then you are the owner, one incident you meet then you are having right. So you need a packet of such things, then only you can say that you are the owner or largely the right. So I'll come to that, the superset, okay, as well as the subset. So right to possess, physical occupation, right to use, enjoy the resource, again right to manage. Now suppose if you have two things, right to physically occupy and enjoying the resources. Any commodity which we buy, for example this computer, I am physically occupying it and enjoying the computer, okay, but many part of this computer I cannot even alter because I have no right. Okay, so this comes in another setup which is called intellectual property, or I'll come to that thing, and all of us know this. So the third one is called the right to manage. Again, my computer is being managed by myself, decided the boundary. Okay, I can actually break it and all physically I can do, but I cannot alter the software which I buy. If I do that, then I am actually infringing or violating that copyright of that software. All right, so I have right to manage. I can operate it, I can enjoy it, I can physically occupy it, but I cannot decide the boundary or where, which was Richard Stallman had done long back. So created a new free software because he can't decide the boundary which he want to use. So this is what is actually the management. So then what is, are you the owner of the software? You are not the owner of the software. So right to income. Now out of it you can have this sort of thing which is called right to income, right to receive it, right to capital, again used for production of information or production of income, etc. One is right to capital, that is for use of this particular information or particular piece with you for the production of income as well as information or whatever you can actually. So that is also very important. Whatever we having owned or whatever we are having may earn you a kind of capital, or it is act as a kind of capital. And the fifth one is right to security, immunity from expropriation, borrow against it. And from this point on, it comes with the immunity aspect of what Hofield said. So you are immune from expropriation or borrow against it. So this is very important, and again the perpetuity, unlimited time, etc. is there. So there is also transmissibility things. That is, it defines that there is no time. There is the ownership, enjoyment of that comes with perpetuity or unlimited time. And again, there is no terms. That is, right down terminate. There is no term means if I am an owner of the things, then under no circumstance and somebody says that your term of ownership is done. So if somebody says, then I am not the owner of the thing anymore, because that's making a boundary of what I can use, etc. So then comes with the prohibition of harmful use, that I cannot create hazards or nuisance. No, even if I am actually having or enjoying or possessing all kinds of this thing, but I am not actually supposed to do harm to others. So this is a very, very important thing as far as this property. If so, then I am also liable in that sense. So the liability to execute, that prevention from loss through solvency or any kind. So nobody can take it actually. If liability to execution comes as part of it, then nobody can take it. These 10 incidents are very crucial, and it seems normal to assume all this thing, and whatever left is comes under the residuary character. That is, whatever, if I am the owner, all the 10 I am enjoying, then I have a possibility that whatever is left also I am so supposed to. That whatever left is actually a very flux term, that is anything can comes inside. So that is, owner has all right, not specifically excluded. So no, the point is again, nothing is actually supposed to be excluded. So all that comes under this thing. So if I am having all this 11 incidents of this kind, then definitely I am the owner. Not only I am an owner, this kind of owner is called an absolute owner. So nobody can challenge anything of anything. So then that kind of person is only called an absolute owner in that sense. So hence we conclude that one's property rights to a particular benefit streams are rarely absolute. Now again, it is quite interesting that this from this incident of property, it is very difficult to establish that all the 11 characteristics is going to be met. Just like what Arrow said in the Arrow's impossibility theorem, that is, all commonsensical necessary things, if you combine together, and it is very difficult to satisfy all the necessary things which what we think to make a decision. So that decision leads to a social decision. So this is what is actually same the case with the incidents of ownership. Then suppose all these 11 incidents are put up, then I am going to be the absolute owner. Then nobody can challenge me. If I am the absolute owner, then even the state cannot. Then this is actually contradicts to the. It is actually self-contradicting. That is to the fact that it has to be approved by a third party. That means, suppose I am the absolute owner, then nobody is above me on that particular thing. All right. Why? Because if government gives this thing, then government can take also. So and then I am not the absolute owner of that thing. So if God can give us, this is all comes from the divine right theory or kind of sensibility which we all have. That is, it is given by God. So God is absolute, then we are not absolute. Okay. Then if I am not absolute, how can I have an ownership which is an absolute ownership? Now we all already from the rights perspective know that some third party has to accept your right. So even God cannot be absolute because no third party is accepting in the perspective of right. So there are so many self-contradicting elements inside this kind of thing. This is what I worked on the possibility of an right or an ownership of absolute nature. It is in a relative sense, you can say that it is right can only be relatively owned or relative. If it is relative, then no absolute right is existing. It implies that no absolute right is existing. That means ownership, right, etc. are going to be relative in that sense. So from that only we conclude that one's property right to a particular benefit streams are rarely absolute. From the perspective of the right holder, key attributes of property rights are assurance, duration, and breadth. Again, your property right or ownership is always depends on assurance, duration, and the breadth of the property. Okay, see, if all these three are there, then it is actually confines that whether you are having absolute right or not. That means you don't have an absolute right if it is comes with assurance, duration, and breadth. So now we move to other aspect which we speak earlier as the issue of entitlement again. See, entitlement these days, as I said, economists are not interested to talk about a right or even ownership. See, interestingly, the 11th incident of ownership, which is called the residual characteristics. This is one concept which was worked by Oliver Hart and Ben Armstrong and other people, and they got Nobel Prize in this particular concept. That is, whatever left can be enjoyed by the firm. Okay, in the contract, the firm's contract theory. So they were trying to see things that who the age-old proposition or question was, who is going to have profit, or why, what is the legitimate claim of profit? And there are many people say that okay, there is CEO, there are other things, so if everybody is being treated as employees, then everyone gets a benefit. Then how some firm can actually get a profit? So what is the legitimate claim of profit? They were worked on this time, whatever, if they have all this incident, and whatever left can also be possessed or owned by this firm. So therefore firm is having a legitimate claim over the residual money or whatever benefit which is left over after paying all these things, because firm is the residual claimant of profit. So we call it firm is the residual claimant. So people like Oliver Hart and all worked on this and got Nobel Prize in this regard. But there are a lot of opportunity in working with these concepts in the future research, and there are many people who work on it, especially in the United States, and people who work on all this aspect. So now let's move to the question of what is an entitlement. An entitlement is an entitlement to perform or refrain from certain actions, or an entitlement that other people perform or refrain certain actions. So this is an entitlement is something which you are entitled to do, only you are, not anybody. So it is entitlement is normally entitlements are something which is non-transferable. This is a problematic one, but anyway, this is the next lecture which I am going to talk about is actually about entitlement, and which is a serious perspective brought out, because this is something economists are interested in. So let me conclude today's lecture here. So thank you for your patient listening, and I hope that the lecture brought some insight into your understanding of what is property, right? And if you have any comment on it, please post the comments freely. Thanks once again. So have a good day.